Connecticut has a tenant protective framework that creates more complexity around rent increases than most New England states. While Connecticut doesn't have traditional statewide rent control that caps the percentage of an increase, the state's strong tenant protections, including just cause eviction for certain populations, robust anti-retaliation provisions, and active local housing programs, create a regulatory environment that landlords must navigate carefully. The governing law is found in Connecticut General Statutes Chapter 830 and Chapter 831, which cover landlord-tenant relations and summary process. Connecticut does not currently have a statewide rent cap that limits the dollar amount or percentage of a rent increase. A landlord can technically raise the rent by any amount, provided they follow proper procedures and the increase isn't motivated by an illegal purpose. However, Connecticut has been one of the most active New England states in debating additional rent regulation. Multiple bills proposing rent caps, enhanced notice requirements, and other restrictions on rent increases have been introduced in the Connecticut General Assembly in recent sessions. The political conversation around rent regulation has been intense, driven by the state's high housing costs, particularly in the Fairfield County communities near New York City, and growing affordability challenges in cities like Hartford, New Haven, and Bridgeport. Connecticut does not have a preemption statute that prevents local governments from enacting rent regulations. This absence of preemption means that individual municipalities could theoretically adopt their own rent control or rent stabilization ordinances. While no Connecticut municipality has enacted traditional rent control to date, some communities have explored or implemented other forms of tenant protection that affect rent increases indirectly. Several Connecticut towns have enacted fair rent commissions, local bodies with authority to review rent increases that tenants consider excessive. Under Connecticut General Statutes Section 7-148B through 7-148F, any municipality can establish a fair rent commission. These commissions have the power to investigate complaints about rent increases, hold hearings, and determine whether an increase is so excessive as to be harsh and unconscionable. If the commission finds that an increase is unconscionable, it can order the landlord to reduce the rent to a level it determines to be fair. This Fair Rent Commission framework is unique to Connecticut and creates a local mechanism for challenging rent increases, even without formal rent control. The standard, harsh and unconscionable, is higher than simply being above market rate. A rent increase isn't unconscionable just because it's large, but an increase that is wildly disproportionate to market conditions, operating costs, and the quality of the housing could be found unconscionable by a fair rent commission. Not all Connecticut municipalities have established fair rent commissions. The process is optional. But several cities and towns have active commissions, including Hartford, New Haven, Bridgeport, Stamford, and others. Landlords in these communities should be aware that tenants have the option to file a complaint with the commission if they believe a rent increase is excessive. For month-to-month tenancies statewide, the landlord must provide advance written notice before a rent increase takes effect. Connecticut does not specify a single statutory notice period exclusively for rent increases. The general practice and the standard applied by courts is that the landlord must provide at least one rental period's notice, which for a monthly tenancy means at least one full month. So if rent is due on the 1st and you want the increase to take effect on May 1st, you should deliver written notice by April 1st at the latest. However, some sources and practitioners recommend providing longer notice for significant increases. In municipalities with fair rent commissions, providing only the bare minimum notice for a large increase can itself contribute to a finding of unconscionability. Providing 60 or 90 days notice for significant increases demonstrates good faith and reduces the likelihood of a commission challenge. The notice should be in writing and should clearly state the current rent, the new rent amount, and the effective date. Connecticut doesn't prescribe a specific statutory form for rent increase notices, but clarity and proper documentation are essential. Deliver by a documented method. personal delivery, certified mail, or another verifiable means. For fixed-term leases, the rent is locked in for the duration of the lease term, unless the lease includes a provision allowing mid-term increases. At renewal, the landlord can propose a new rent, but the tenant can challenge the renewal amount through a fair rent commission if one exists in the municipality. When the lease approaches expiration, the landlord should communicate the proposed new rate well in advance. For week-to-week tenancies, the notice period for rent changes is 1 week, 7 days. Now here's where Connecticut's framework interacts with the state's just cause eviction protections in a way that affects rent increases. As we discussed in our Connecticut lease termination video, Connecticut provides just cause eviction protections for tenants who are 62 years of age or older and for tenants with disabilities. For these protected tenants, a landlord cannot terminate the tenancy without specific cause. This means that a massive rent increase designed to force an elderly or disabled tenant out, rather than reflecting a genuine market adjustment, could be challenged as a constructive eviction or as a violation of just cause protections. For all other tenants, Connecticut technically allows no-cause termination through the notice to quit process. But the practical reality is that Connecticut's housing courts scrutinize landlord conduct carefully, and a rent increase that appears designed to circumvent tenant protections rather than reflecting legitimate business factors can face judicial pushback. Now let's cover the statewide restrictions. Rent increases cannot be retaliatory. Connecticut has one of the strongest anti-retaliation statutes in the country under Section 47A-20. Landlords cannot raise rent in retaliation for a tenant exercising any legal right, including making a good faith complaint about habitability, reporting code violations to a government agency, organizing or joining a tenants organization, testifying in any proceeding related to the landlord's obligations, and exercising any right under Connecticut landlord-tenant law. Connecticut's anti-retaliation provision creates a rebuttable presumption of retaliation if the landlord takes adverse action within 6 months of the tenant's protected activity. 6 months is a significant protection window. The landlord must prove by clear and convincing evidence that the increase was not retaliatory, and clear and convincing evidence is a higher standard than the preponderance of evidence standard used in most civil matters. This elevated burden of proof makes it harder for Connecticut landlords to overcome the presumption and makes retaliatory rent increases exceptionally risky. The consequences of a retaliatory rent increase in Connecticut can include the invalidation of the increase, liability for actual damages and punitive damages, and attorney's fees. The combination of the 6-month presumption, the clear and convincing evidence standard, and the potential for punitive damages makes Connecticut one of the riskiest states in the country for retaliatory landlord conduct. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and Connecticut's own fair housing law, found in Connecticut General Statutes Section 46A-64C, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, sexual orientation, gender identity or expression, disability, familial status, marital status, age, ancestry, lawful source of income, or status as a veteran. Connecticut's anti-discrimination protections are among the broadest in the nation. The lawful source of income protection is particularly relevant to rent increases. A landlord cannot raise rent specifically to push out a tenant who receives Section 8 vouchers, Social Security disability, veterans benefits, or other lawful income. A rent increase that appears targeted at subsidy recipients, while other comparable tenants are not similarly affected, can result in a discrimination complaint with the Connecticut Commission on Human Rights and Opportunities and significant liability. The Commission on Human Rights and Opportunities investigates complaints and can take enforcement action including ordering damages, injunctive relief, and civil penalties. Connecticut's broad anti-discrimination protections and active enforcement create substantial liability exposure for discriminatory rent increases. From a practical standpoint, Connecticut's rental market varies dramatically between its Fairfield County Gold Coast communities and the rest of the state. Fairfield County, including Stamford, Norwalk, Greenwich, Westport, Bridgeport, and Danbury, is part of the New York City metropolitan area and has some of the most expensive rents in New England. Stamford has emerged as a major corporate center with a strong financial services sector, and rents in the city reflect its proximity to Manhattan and its own economic vitality. Greenwich commands ultra-premium rents driven by wealth management, hedge funds, and proximity to New York. Bridgeport, Connecticut's largest city, has a more affordable and diverse rental market than its Gold Coast neighbors. The city has experienced some revitalization, but also faces persistent economic challenges. Rents in Bridgeport are significantly lower than in Stamford or Norwalk, and pricing power varies considerably by neighborhood. New Haven, home to Yale University and Yale New Haven Hospital, has a tight rental market driven by the university and the massive healthcare complex. Rents near Yale and in desirable neighborhoods like East Rock and Westville are high relative to the city's size. The student and medical professional population creates consistent demand. The broader New Haven market includes more affordable neighborhoods where pricing power is more limited. New Haven has an active Fair Rent Commission that reviews tenant complaints about excessive rent increases. Landlords in New Haven should be aware that tenants have this avenue for challenging increases they believe are unconscionable. Hartford, the state capital, has a moderate and challenging rental market. The insurance industry, Hartford is historically known as the insurance capital of the world, and state government provides stable employment, but the city has faced economic difficulties and population decline. Rents in Hartford are among the lowest in the state's major cities, and pricing power is limited in many neighborhoods. Hartford also has a Fair Rent Commission. The suburban communities along the I-91 and I-84 corridors, including West Hartford, Glastonbury, Farmington, and Simsbury, have stronger markets driven by families seeking quality schools and suburban amenities. Rents in these communities are higher than in Hartford proper. New London and the southeastern Connecticut coast have a rental market influenced by the naval submarine base New London, the primary home port for the U.S. submarine fleet, Electric Boat, the Coast Guard Academy, and Connecticut College. The military and defense presence drives significant rental demand. Military tenants' housing budgets are tied to BAH rates, and landlords near the base should monitor annual BAH adjustments when planning increases. The University of Connecticut in Storrs drives student housing demand in the rural northeastern part of the state. Student housing follows the academic calendar, with rent adjustments at the beginning of each lease cycle. One critical best practice for Connecticut landlords: determine whether your municipality has a Fair Rent Commission before implementing any rent increase. If it does, be aware that your tenants have the right to challenge increases they consider excessive. The best defense against a Fair Rent Commission challenge is documentation, showing that your increase is justified by market conditions, operating cost changes, and property improvements, and that the resulting rent is consistent with comparable units in the area. Another best practice, given Connecticut's 6-month anti-retaliation presumption and the clear and convincing evidence standard, maintain meticulous documentation of the business justification for every rent increase. Keep records of market comparables, operating cost changes, property tax bills, insurance premiums, and capital improvements. If a tenant has filed a complaint within the past 6 months, your documentation must clearly and convincingly demonstrate that the increase was planned independently. For landlords in Fairfield County competing with the New York metro market, track both Connecticut and New York area rental trends when setting prices. Many of your tenants chose Connecticut specifically because it offers lower rents than Manhattan or certain New York suburbs, while still providing access to New York employment. Keeping your rents competitive within this comparative framework helps retain tenants. Connecticut's insurance costs have been increasing, and property taxes in the state are among the highest in the nation. These documented cost drivers provide legitimate justification for rent increases. When communicating an increase to tenants, referencing specific cost increases, without being legally required to, demonstrates transparency and can reduce resistance. For landlords near Naval Submarine Base New London and other military installations, understanding BAH rates is essential. The defense industry presence in southeastern Connecticut, including Electric Boat's submarine construction operations, also generates civilian rental demand from defense workers. The military and defense community represents a substantial and reliable tenant base. Connecticut also has specific requirements for manufactured home park lot rents under Chapter 412. Landlords who own or manage manufactured home parks must follow specific notice and procedural requirements for lot rent increases, which are more detailed than the general residential provisions. For Connecticut landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority. Given Connecticut's lawful source of income protections, the interaction between voucher rules and anti-discrimination law is important. Submit increase requests well in advance. Connecticut requires landlords to return the security deposit within 30 days of the tenant vacating, or within 15 days of receiving the tenant's forwarding address, whichever is later. The deposit must be held in an escrow account at a Connecticut banking institution, and interest must be paid to the tenant annually. Connecticut limits the deposit to 2 months' rent. Failure to comply with any of these requirements can result in the landlord being liable for double the amount of the deposit. While these rules don't directly regulate rent increases, Connecticut's detailed deposit requirements demand careful attention. For the complete guide to Connecticut rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our landlord-tenant law series.